Here in Arizona, we have some foreclosure rescue laws, but not to the extent of Colorado's. And I think Colorado, maybe Washington, Oregon have very similar foreclosure protection laws. So talk to us about that, because I think that's where a lot of these, investors are really going to make mistakes. Is they get a form and then they decide, oh, well, I can use it everywhere because a purchase contract's a purchase contract. Right. It doesn't work that way. And I know it doesn't work that way in Colorado. No. So talk to us, if somebody's 30 days late on a mortgage payment and you're going to go in and you're going to do a subject to transaction, what are the things in Colorado that have to be in that purchase contract?
Yeah, so you have to have at least 12-point font size. Can you imagine? What are you in for? Armed robbery. What are you in for? Font. criminal violation of the statute. So it's got to be like a 12-point font. And thankfully, the state Department of Real Estate Commission has a foreclosure form, specifically for those types of transactions. It has the disclosures, and you got to give them the right rescission. And people think it's 3 days. It's not. It's midnight the third business day following the day you signed it, which is, it's hard to calculate if you have to read it a few times to figure that one out.
Well, and if I remember correctly, you can't just say that. You have to actually calculate for the seller.
Because I've lobbied this whole thing, and I wrote about a third of the statute when I was president of my RIA, to help out investors. Originally, they wanted a 10-day rescission, which is absurd. And they wanted no subject twos in foreclosures, which was absurd too. So I said, let me write a disclosure, so we can do subject to. So we have to put that in. You have to give them a right of rescission form that says, I wish to rescind. And I go beyond that too with people and because the problem is you can rescind orally. You don't have to use the form. So what if someone calls you up after day 2 and says, I don't know about this. Is that a rescission? Do you need a new contract? The thing is, you don't know. So I make people sign after the 3 days are up and they haven't rescinded them, make them sign an affidavit that says 3 days have expired and I have not rescinded at any time. So they can't come back later and say, I called them. Right. So you got that. And then just a bunch of, my own disclosures of things that I put in there, such as, it's going to remain in the seller's name and it's going to remain on your credit report. It's going to affect your ability to get a new loan, your VA eligibility if it's a VA loan, et cetera, et cetera. And then we have rules about sale lease back with an option, which I always think is a terrible idea anyway. So if you want to buy subject to and sell it back to the owner on a lease with option to repurchase it, there's all kinds of rules regarding that I wrote. I tell clients, just don't do them, If they're in default, you're setting them up for failure.
Well, let me ask about the Foreclosure Protection Act, and I'm knowledgeable about it, and just because I'm in this space, and so I kind of keep up on this kind of stuff, but I don't know the ins and outs, obviously, like you do. Is there a structure where you could basically acquire either possession or an interest in the real estate subject to, without having to worry about or comply with the foreclosure protection law? A lease option might be an example of what I was kind of thinking about, but I don't know.
Well, a lease is not a purchase, and an option is a property right. So you would, but I don't think I would want a lease option with someone in default of payments. I would want the deed and make up the back payments and get it subject to. Unless it was like one payment, maybe. I've done that a few times. But if someone's 9 payments behind, they better have a lot of equity for me to want to do an option. It's too risky on the buyer's side, because if the seller, as you know, the seller files foreclosure, the trustee in bankruptcy can cancel that executory contract and you're out of luck. It happened to me once. I lease optioned a property from somebody, sublet it to somebody to live in with an option to buy from me. The option to buy from me was higher than the option I got from the owner. And 6 months later, the seller files for bankruptcy. And the trustee in bankruptcy canceled my lease option, which he has the right to do. It's what's called an executory or unfinished contract. So,
yeah, exactly.
If I had just gotten the deed, that's a completed transaction, and they couldn't cancel that. So yeah, that's a risk of of doing a lease option with someone who's in default, because if they're in default of mortgage, likely they're in default of credit cards and car payments, and they may end up in this Chapter 7. So it's risky.
Yeah, great point. What about a contract for deed or agreement for sale, as we call it here in Arizona?
Right.
Would that fall under the Foreclosure Protection Act in Colorado?
Yes, that's considered a sale. So it would require and the same problem I have with that, if someone's in 9 payments in default and they're facing potential Chapter 7, an installment land contract or contract for deed is an executory contract, and the can cancel it, and you're out of luck. If if I'm just going to acquire it to rent it, okay, I'll take that risk. But if I'm reselling it on a wrap, I'm putting myself in a precarious situation if that seller files bankruptcy.